Imagine you finally buy that dream property. You know you saved for years, you sign the deed, and you even go down to the registry to record it.
Right. You feel totally secure.
Exactly.
Yeah.
But then, a few months later, there's a knock at the door. And someone else is claiming they bought that exact same land 5 years ago. And the terrifying part of our exploration into the source material today is that the law might actually take their side.
Yeah, it's a legal nightmare that honestly happens way more often than you'd think. So today we're unpacking the Philippine land registration transition, moving from the old Spanish mortgage law to the modern Torrens system.
Right, under PD 1529.
Mm-hmm.
And we're looking at Act 3344 and Section 113 to figure out why the type of land you buy is either a completely safe investment or just a massive gamble.
Exactly. We're essentially looking for the gold standard of ownership here.
And I noticed in the materials there's this specific date that just kind of changes everything. June 11, 1978. What exactly happened then?
That is the hard cutoff. So on that day, the Spanish mortgage law was completely discontinued. If a piece of land wasn't brought under the Torrens system by then, it is legally just unregistered land.
So if your deed predates 1978 and just hasn't been touched since.
You aren't holding a modern title. No, you're holding a historical artifact, basically. One that the current legal system barely even recognizes.
Okay, let's unpack that gold standard first. With Torrens-titled land, the sources say registration is the operative act. What does that actually mean for a buyer?
It means the act of registering is what actually transfers the ownership to you. It gives constructive notice to the world.
Which is a legal way of saying everyone is officially assumed to know you own it once it's recorded.
Right. You only need to care about what's on the face of the title. If a lien or a debt isn't written right there on the document, you don't have to go playing detective. The document is the absolute authority.
That sounds perfectly secure. But then we hit the unregistered side of things, and things get really messy. The phrase in the text is that registration is without prejudice to third parties with a better right.
Yeah, it's a massive trap. On unregistered land, your registration does not grant you absolute safety.
Because if the person who sold you the land had already sold it to someone else, even if that first buyer never recorded a single thing,
that first buyer still likely has the better right. Your registration means nothing if the seller had nothing left to sell.
Wait, so I could do everything right, pay the taxes, go to the registry, and still lose my house because of some secret better right from years ago. Why even have a registry for these lands then?
It's really more of a record-keeping system than a guarantee of ownership. And watch out for the proper registry rule, too.
Oh, right. If you accidentally record a Torrens-titled property in the Act, 344 books.
Exactly. The book's meant for unregistered land. That registration is legally invisible. It provides zero protection.
It's like trying to register your car at the post office.
Exactly. You have a receipt, but the traffic cops won't care.
Which brings us to the race to the registry.
Yeah.
If two people think they bought the exact same piece of land, who wins?
According to Article 1544 on double sales, there's a strict hierarchy. First, the person who recorded it in good faith wins.
And if nobody recorded it?
Then the person who physically took possession first wins. And if it's still a tie, it goes to whoever holds the oldest title.
But what if I buy land at an auction, like a court-ordered execution sale to pay off a debt? Surely a court stamp gives me protection.
You would think so, but you're taking a huge risk there too. In an execution sale, you just step into the shoes of the debtor. You only get what they actually owned at the very moment of the levy.
The legal seizure of the property. This is where that Carumba versus CA case comes in, right?
Yes. A man bought land privately but didn't register it. Later, a court seized that same land for the original owner's debts and auctioned it off.
And the court ruled that because the private sale happened first, the original owner had no dominical interest left.
Right. The legal soul of ownership was already gone. The auction buyer essentially bought empty shoes.
And just to add one more layer, this applies to buildings too.
Always. The accessory follows the principle. In the unregistered system, you cannot separate the house from the lot. If it's not annotated on a Torrens title, the building does not exist as a separate legal entity.
So if you are looking at a deed right now, you need to know if it is under the Torrens system or Act 3344. One is a shield and the other is a legal gamble.
Absolutely. It's all about understanding that operative act.
Which makes me wonder, if the operative act of the government is what truly creates ownership, is that deed in your drawer actual proof that the land is yours? Or is it just a story you're telling yourself until someone with a better right comes knocking?
Okay, let's dive into a scenario that is every property buyer's worst nightmare. Picture this. You finally bought your dream piece of land. You've saved up, signed all the papers, you've got the deed right there in your hand. And then someone else shows up, waiving their own deed for the exact same property. This isn't just a bad dream, it's a legal minefield, and we're about to walk through it together.
So, you paid your money, you've got the paperwork. But so do they. Who actually has the rightful claim? Well, the answer isn't as simple as you think, because in property law, it's like you're dealing with two completely separate worlds, and each one plays by a totally different set of rules.
So, to figure out who gets to keep the land, the very first question you have to ask is, which of these two legal worlds does the property actually live in? Let's break them down.
On one hand, you've got registered land. This operates under something called the Torrens system. Think of it like a central bank vault for land titles. The government basically guarantees your ownership. That certificate is the ultimate proof. But then you have unregistered land, which is a throwback to an older system. Here, the government is just keeping a logbook of claims. And believe me, that's where things can get really, really messy. Now you're probably thinking, wait, if one system is like a secure vault, why on earth are we still using this other, more complicated one? And that's a great question. The answer is all about history. The unregistered system is basically a ghost from a past legal era, and you've got to understand where it came from to avoid its traps. See, this whole system is a holdover from the old Spanish mortgage law, but the big moment, the real turning point, came in 1978. A presidential decree essentially froze that old system in time. It declared that any property not already in the new, modern registered system was now officially unregistered land, and that single decision still echoes through property deals today. Okay, so we've got these two systems running in parallel. Now let's see what happens when they smash into each other in the most dramatic way possible, the double sale. This is it, the nightmare scenario we started with. A seller, whether they're shady or just forgetful, sells the exact same property to two different unsuspecting buyers. So who wins? The answer depends entirely on which world that land belongs to, registered or unregistered. And this table just lays it all out perfectly. For registered land, the rule is crystal clear. The first person to register the sale in good faith wins. End of story. Registration is king. But for unregistered land, it's a completely different ballgame. The winner is the person who can prove they have a better right, and get this, they can win even if they never registered their purchase at all. You know, the logic here is pretty interesting. A famous court ruling puts it just perfectly. When you buy unregistered land, you are stepping into the shoes of the person you're buying it from. That means you can only get the rights that the seller actually had to give you at that exact moment in time, not a single thing more.
Now, let's flip that completely on its head and look at the world of registered land. Here, a buyer acting in good faith doesn't have to be a detective digging into the past. They are only responsible for what is written right there on the face of the title. If that title looks clean, they can rely on it, period. This all leads us to the million-dollar question for unregistered land, right? What in the world is this better right that can just pop up out of nowhere and blow up what seems like a perfectly good sale? Well, it's not as simple as just having an older document. A better right is a superior claim that's built from the whole story, the combination of all the facts and circumstances. It's about proving your claim is just plain more legitimate, based on everything that happened, not just one piece of paper. A huge case, the Carumba case, gives us a perfect playbook. Here's what happened. A seller sold land to a buyer with just a private document, but, and this is the key, that first buyer then took physical possession of the land. The court said that by doing that, the seller had basically handed over all their rights. So when a second buyer showed up later and bought the same land at a public auction and registered it, it was too late. The seller had nothing left to give. That first buyer's prior sale, combined with their possession, created the better right. Game over.
Look, it is absolutely critical to understand just how separate these two systems are. They are like oil and water, because mixing them up isn't just a small paperwork mistake, it can be a complete and total financial disaster. The rule on this is absolute. You cannot mix the registries. If you have land with a modern Torrens title, that's registered land, you cannot go and record your sale in the old logbook for unregistered land. If you do, the law says it's the same as if you never registered it at all. And the fallout from that is huge. That registration is legally invalid. It doesn't tell the rest of the world that you have a claim. It means your deal is only binding between you and the seller, but it gives you zero protection from some other innocent person who comes along later and registers their purchase in the correct book. And this isn't just about the land. It applies to any buildings on it too. Your claim could be completely wiped out. So after navigating these two wild, complicated legal worlds, what is the one crucial thing you need to take away from all this to protect your investment and avoid this whole nightmare?
Let's just put these two side by side one last time. In the world of registered land, the winner is the first one to register in good faith. The title is everything, and registration is the final word. But in the world of unregistered land, the winner is whoever has that better right, which is based on the history of what happened, like the sale and possession. Here, even a registered document can lose to an older, stronger claim. If you remember only one thing from this entire explainer, please let it be this. You have to know the status of the land first. Is it registered or is it unregistered? Because that one single fact determines the entire rule book that will either protect or destroy your purchase. And that leaves us with the one question that could save you from a world of financial and legal pain. Before you sign a single thing, before you hand over a single dollar, are you absolutely 100% certain which world your property lives in? Because finding out afterwards could mean you don't actually own it at all.
So, imagine this scenario for a second. It's the kind of thing that doesn't just keep you up at night. It's the kind of thing that completely ruins lives.
Oh, absolutely. It changes the entire trajectory of a family's history.
Right. So you finally buy a piece of land. It's exactly what you wanted.
Maybe it's a farm down in the province.
Yeah. Or maybe it's a plot for a future home. Yeah. Where you plan to retire, you save up, you pay the seller, you sign the deed, you shake hands.
And it feels done.
It feels permanent. You take possession, you start clearing the tall grass. Maybe you put up a fence to mark your territory.
You'll plant a few mango trees.
Exactly. You are the owner. You paid for it. It's yours.
That really sounds like the happy ending for most people.
But here is the horror movie sequel.
Oh, no.
You didn't record that deed?
Ah.
You didn't go down to the registry of deeds to make it official in the big books?
Maybe you didn't have the money for the fees right then.
Or maybe you just thought, hey, I have the paper. I'm living right here on the land. What could go wrong?
Right. You just put the papers in a drawer and forgot about them entirely.
And that right there is the fatal mistake.
Because in the eyes of the law, sometimes reality isn't what's actually happening on the ground.
It's what is written in the books.
Precisely.
So 2 years later, the guy you bought it from, the original seller, he gets sued by someone else for a massive debt.
A debt that has absolutely nothing to do with you.
Nothing at all. But he loses the lawsuit. So the sheriff comes looking for assets to seize to pay off that judgment.
And because you never registered the sale,
The public records still show the land in the seller's name.
the sheriff checks the registry, sees the seller's name, and just says, bingo.
So the sheriff auctions off your land.
Wow.
Another guy buys it at the auction. And this new guy, he immediately runs to the registry of deeds and registers his purchase.
He does what you didn't do.
Right. And now he shows up at your doorstep with a piece of paper saying he owns the land.
Oh.
And he tells you to get off his property.
This is the classic double sale nightmare.
It really is.
It's a conflicting claims scenario that happens way more often than people want to admit. It is an absolute legal minefield.
So the burning question we are answering today for you, the listener, is who actually owns the land?
Is it you, the person who paid first and is living there tending to those mango trees?
Or is it the guy who bought it at the auction and registered it first?
It is a terrifying question, and I think most people would instinctively say, well, the guy who registered it wins, right?
That's what the law is for. The law loves paperwork.
But the answer is actually, well, it depends.
It depends.
Yeah.
Come on, that's the most classic lawyer answer ever.
I know it is. But in this case, it depends entirely on one specific, really crucial distinction.
Which is
the land registered under the Torrens system, or is it unregistered land?
and that single distinction changes the entire outcome of the story.
It changes everything.
Well, that distinction is exactly the rabbit hole we are jumping into today. We are doing a deep dive into the chaotic, high-stakes world of Philippine land registration laws.
We're going to look at the better right doctrine, the absolute nightmare of the wrong box theory,
Oh, I can't wait to get to the wrong box theory.
and why recording your sale isn't always the final word.
We have a really serious stack of sources today. We are looking at pre-bar examination review pointers involving Presidential Decree 1529, Act 3344, and the Civil Code.
We're going to parse through the logic of Supreme Court justices like J.B.L. Reyes, Gang Keiko, and Puno.
Just to understand how the law decides who actually wins in these property wars.
So what is our primary mission here today?
Our mission is to decode this concept of a better right. We need to understand why, in some cases, the person with the registered paper wins.
And in other cases, surprisingly, the person with the unrecorded paper wins.
We want to equip you to look at a piece of land and understand the invisible legal risks attached to it.
We really want you to understand that not all registrations are created equal.
Okay, let's start at the very beginning. We have these two worlds, registered and unregistered.
Yes.
It feels like we have two different operating systems for land running at the exact same time, like Windows and Mac, but completely incompatible.
That is a brilliant analogy. It really is like two operating systems.
So how do we end up with two?
To understand why, we have to go back to history. We have to go back to the Spanish era.
Right.
For a very long time, land registration in the Philippines was governed by the Spanish mortgage law. That was the old OS.
People recorded their titles and their transactions under this Spanish law.
Exactly. This was back when everything was handwritten in that elaborate script.
In big, dusty, leather-bound books.
And for a long time, that was the system. If you had a title under the Spanish mortgage law, you were the owner.
But systems change.
They do. The Philippines moved toward the Torrens system, which is a system of title registration where the state actually guarantees the title.
It's the modern standard.
Yeah.
We don't use the Spanish mortgage law anymore at all, do we?
No, we don't. And this is a really critical starting point. The system of registration under the Spanish mortgage law was officially discontinued.
So it wasn't just phased out slowly over decades where you could kind of choose which one to use.
No, it was a hard stop. It happened via Presidential Decree 892, and it was further reinforced by Section 3 of Presidential Decree 1529.
Also known as the Property Registration Decree.
Yes. That sounds like the Bible for this stuff, doesn't it?
It really does.
It essentially is the Bible for land registration. And Section 3 was crystal clear. The Spanish mortgage law system is dead. It's obsolete.
So let's say I have a title that was recognized under the Spanish mortgage law.
Okay.
Maybe it's an old yellowing piece of paper from my great-grandfather that's been kept in a cedar chest for almost a century. Is it just trash now? Does it mean I don't own the land?
It's not trash per se. It still proves some historical right.
Okay,
It
right.
proves that your family definitely has a claim. And this is a huge, but it is not a Torrens title.
So what is it considered?
Here is the strict rule. All lands that were recorded under the Spanish system, which were not yet converted to the modern Torrens title system, are now classified as unregistered lands.
Unregistered. That word just sounds legally precarious.
It is.
It sounds like driving a car without insurance or flying without a parachute.
It is incredibly precarious. Specifically, after June 11th, 1978, the law effectively said we are totally done with the Spanish system.
So if you have a transaction involving land that was formerly covered by the Spanish mortgage law, you cannot use the old Spanish books anymore.
Right. You have to use a new system for these specific unregistered lands.
This creates a really weird limbo, doesn't it?
It does, because the ultimate goal is for everyone to eventually get a Torrens title.
But until they do, they are stuck in this middle ground.
Exactly. It's a purgatory.
Purgatory is a good word for it.
You aren't in the secure heaven of the Torrens system yet, but you aren't in the total wilderness of having no records at all. You are just in the world of unregistered land.
Okay, so practically speaking, if I buy a piece of land today that hasn't been converted to a Torrens title yet, so it's technically unregistered, where do I go?
You still have to register it somewhere.
Right, I can't just keep the deed under my mattress. There has to be a place to record the sale so the world knows I bought it.
There is. You go to Section 113 of PD 1529.
Section 113.
Yes. This is the section that governs the recording of instruments relating to unregistered lands.
Okay, I'm picturing a specific window or desk at the Registry of Deeds just for this.
That's a good way to picture it. And these transactions are recorded in a very specific set of books at the registry.
Separate from the Torrens books.
Completely separate. Originally, this was provided for under Section 194 of the Revised Administrative Code as amended by Act Number 3344.
Act 3344. I see that mentioned a lot in the source materials.
You will hear us refer to Act 3344 a lot today. When lawyers say it's an Act 3344 registration or ask, is this 3344 land, they mean it's a registration of unregistered land.
So let me try to visualize this for everyone. We have the Torrens system.
Which is the gold standard.
The modern system, the iOS in our earlier analogy.
Right.
And then we have the Act 3344 system, which is for everything else. The leftovers, the legacy code, the stuff that just hasn't been upgraded yet.
That's totally fair. It's the backup system. But here is the catch, and this is honestly the most important part of this entire section of the deep dive.
Okay, lay it on us.
When you register something under Section 113 or Act 3344, it does not give you the same protection as the Torrens system.
How so? I thought the whole entire point of registration was protection. Like, I registered it, therefore I'm safe.
Usually, yes, that's the natural intuition. But the law explicitly says that registration under Section 113 is, and I quote, without prejudice to a third party with a better right.
Without prejudice to a third party with a better right.
Yes.
That sounds like a massive disclaimer you'd see buried in the fine print of a shady contract.
Yes.
Like, results not guaranteed.
It effectively is a giant disclaimer.
So what does that actually mean in practice?
It means that while you can record your deed, and you absolutely should record your deed to notify the world, the act of recording it in the 3D344 book doesn't guarantee you are completely safe.
Safe from what?
Safe if someone else comes along with a claim that the law considers better. It explicitly yields to better rights of third persons acquired prior to your registration.
That is a huge difference, because usually in law school or even just in general business practice, we're taught that first to register wins. Speed is everything.
Exactly.
If I get to the patent office first, I win. If I get to the finish line first, I win. But in the world of unregistered land, it sounds like it's saying, register if you want, but if someone has a better right, you still lose anyway.
Precisely. Registration under Section 113 has a very limited effect on third parties compared to a Torrens title.
It provides some notice, though, right?
It provides notice, yes.
Yeah.
It tells the world, hey, I have a claim here, but it is not an absolute shield.
So it's more like a no trespassing sign made out of flimsy paper.
Whereas a Torrens title is a no trespassing sign made of solid titanium.
I love that imagery. Titanium versus paper. So we are dealing with a system, the unregistered system, that is inherently much weaker.
It is fundamentally weaker by design.
Which begs the question, what actually constitutes a better right?
That is the million-dollar question, and it's where things get really complicated.
Let's unpack this better right concept, because that seems to be the absolute key to unlocking this whole mystery.
It is.
And to do that, I want to bring up the classic problem we teased in the intro, the double sale.
A true classic. Every single law student sweats over this one.
It's a staple of the bar exam for a reason, right? Because it perfectly tests your understanding of legal hierarchy.
Exactly. It forces you to weigh conflicting claims.
So let's set the stage clearly for you listening. Landowner sells to buyer A.
Right.
Then for whatever reason, maybe he's a scammer, maybe he's incredibly forgetful, maybe he's just desperate for cash, that same landowner sells the exact same piece of land to buyer B.
A nightmare scenario.
Who wins?
Well, first, we have to ask the question we started this whole discussion with. Is it registered land or unregistered land?
Okay, let's start with the titanium. Let's say it is registered land, land with a Torrens title.
If it's Torrens land, the rule is found squarely in Article 1544 of the Civil Code.
And what does that tell us?
It gives us a very strict three-step hierarchy of whatting.
Walk us through the hierarchy. Who gets the gold medal in the Torrens Olympics?
Step 1. Who registered the sale first in good faith? That person wins immediately.
Just like that.
Yes. Ownership transfers to the person who, in good faith, first recorded it in the registry of property.
Okay. So speed really does matter there.
Yeah.
If buyer B runs down to the registry while buyer A is taking a nap or saving up for the registration fee, buyer B wins.
Speed is absolutely everything in the Torrens system.
What if neither of them registered it? Let's say they both just kept the papers in a drawer at home.
Then we move to step 2. Who took possession of the property first in good faith?
Like who actually moved in or built a fence?
Exactly. And if neither of them took possession, say it's just an empty lot they both ignored, then we go to step 3. Who has the oldest title in good faith?
But the primary rule, the one that resolves probably 90% of these double sale cases, is simply registration.
Yes. Section 51 of PD 1 Feen 29, which amended the old Act 496, is very clear on this.
What does it say?
It says the actual act of registration is the operative act to convey or affect registered lands.
Operative act.
Yeah.
I really love that term. It sounds surgical. Can you explain what that actually means in plain English for us?
Think of it this way. Without registration, the deed of sale is just a private contract between you and the seller.
It binds just the two of you.
Right. You can sue him if he breaches it, but it doesn't bind third parties at all. It's essentially a private secret.
The rest of the world doesn't know about it and therefore doesn't have to respect it.
But once you register it, that registration becomes the operative act that officially changes the ownership in the eyes of the whole world.
So in a double sale of Torrens land, if buyer B registers first, buyer B wins. Period.
Period. Buyer B doesn't have to look behind the curtain to see if the seller maybe already sold it to buyer A. As long as buyer B is acting in good faith, they can completely rely on the clean title.
That makes the system incredibly efficient. You don't have to play private detective every time you buy property.
Exactly. You just look at the title. If it's clean, you buy it,
Got it.
you register it, you own it. That is the true genius of the Torrens system. It facilitates trade because you can trust the public record.
Okay, that's the Torrens rule. It's clean, it's harsh, but it's very clear. Now, let's throw a massive wrench in the gears.
Alrighty.
What happens if the land is unregistered? Does Article 1544, that hierarchy of speed and registration, does that still apply?
This is where the plot twists. This is where the legal theory gets really interesting and a bit messy.
Messy how?
The Supreme Court has held that Article 1544 applies very differently, or in some specific contexts, is effectively set aside entirely when we deal with unregistered land.
Why? Why would the rules change so drastically just because the land doesn't have a modern title?
Because of that specific phrase we discussed earlier, without prejudice to a third party with a better right.
The disclaimer comes back.
It does. For unregistered land, the mere registration of a second sale in the Act 344 books doesn't automatically defeat the first buyer.
Because the registry isn't the operative act in the same way.
Exactly. It's just a notice. It's not creating the truth the way a Torrens registration does.
It's getting a bit abstract. I think we need a concrete case study to really see this play out in reality.
I agree.
The source material gives us a pretty perfect one. Kurumba versus Court of Appeals.
Kurumba is absolutely the definitive case for this. It involves exactly the scenario you described in the intro with the sheriff at the door.
It perfectly illustrates the concept of the better right.
Mm-hmm.
Let's set the scene for the listener. Who are the players here?
Okay. We have the former owners of the land. Let's just call them the sellers. The year is 1955. On April 12, 1955, they sold a piece of unregistered land to a man named Canuto Kurumba.
Okay, Kurumba. He's our protagonist. He buys the land.
He buys it, but here is his big mistake. Or at least what would be a fatal mistake in the Torrens world.
What did he do?
The deed of sale was only a private document. It wasn't a public instrument notarized in a specific way, and crucially, it was not recorded in the registry of deeds.
So he has a piece of paper, but the government knows absolutely nothing about it. It's totally invisible to the state.
Correct. However, Kurumba did do one thing right. He took possession of the land. He was physically there living on it.
He planted his flag, so to speak.
Yes. So he's living on the land, he paid for it, but he has no public record of the sale. To any outside observer looking at the registry books, the sellers still completely own it.
Okay, the stage is set. What happens next?
Fast forward 2 years, January 1957. The original sellers get sued by a guy named Balbuena.
And Balbuena wins the lawsuit.
He does.
So now the sellers owe Balbuena a bunch of money.
Yes. And since they don't pay up, Balbuena goes to the sheriff. The sheriff looks around for assets to seize to pay off that debt.
And the sheriff checks the books.
The sheriff checks the books and finds this exact piece of land, which, remember, is still in the name of the sellers because Kurumba never registered his private deed.
The sheriff says, great, I'll take that one.
He levies on the land and sells it at a public execution sale.
And who buys it? Let me guess, Balbuena.
Balbuena, the creditor, buys it at the auction.
Typical.
And here is the kicker. Balbuena actually registers the execution sale in the Act 344 books.
Okay, so let's pause and look at the scoreboard here.
Let's do it.
In one corner, we have Kurumba. He bought it first. He has physical possession, but he didn't register anything.
Right.
In the other corner, we have Balbuena. He bought it second at an auction, but he did register it.
And Balbuena goes to court and argues, hey, Article 1544, I registered first. I win. Speed wins the race.
And if this were Torrens land, Balbuena would be absolutely 100% right.
Completely correct. If there was a Torrens title, Balbuena would be the undisputed owner today.
But this was unregistered land.
Yes, it was. And the Supreme Court, with Justice J.B.L. Reyes writing the opinion, ruled in favor of Kurumba.
Wait, the guy who didn't register? The guy with the crumpled private document won?
He won.
That feels completely counterintuitive to everything we know about bureaucracy and the law. Why in the world did Kurumba win?
It comes down to a very specific, almost philosophical, legal concept regarding what a sheriff actually has the power to sell.
Okay, explain that.
Justice J.B.L. Reyes explained that when a purchaser buys unregistered land at a sheriff's execution sale, the purchaser only steps into the shoes of the judgment debtor.
Steps into the shoes. I really like that image.
It's a powerful legal metaphor. It means the purchaser acquires only the exact interest that the debtor had at the very moment of the levy.
He gets exactly what the debtor has. No more, no less.
Precisely.
So we have to freeze time. We have to look at what the sellers actually possessed at the exact moment the sheriff arrived on the property.
Let's do that. Had the sellers already sold the land to Kurumba 2 years prior?
Yes, they had.
Even though it was a private document, the sale was valid and binding between the sellers and Kurumba had taken physical possession.
So practically speaking, at the moment the sheriff arrived, the sellers owned nothing.
They had no dominical interest. That's the formal legal term. They had zero ownership rights left.
Because they'd already transferred it all to Kurumba.
Exactly. So when the sheriff levied on the land, he was levying on literally nothing.
And when he sold the land to Balbuena at the auction, he sold nothing.
Nothing at all.
Wow. So because the sellers had already emptied their rights out, there was nothing for the sheriff to grab. It's like trying to rob a bank vault that's already empty.
That's a perfect way to put it. Or like trying to sell a bag of air. Justice J.B.L. Reyes said the judgment debtor had no real right over the land that could pass to the purchaser at the auction.
Therefore, Balbuena, even though he diligently registered his auction purchase, yields to Kurumba.
Because Kurumba has the better right. He actually owns it.
That is the massive aha moment for this whole topic. For unregistered land, actual ownership plus possession beats a later registered execution sale.
Yes. And the court explicitly said that Article 1544, that rule about registration in good faith prevailing, has no application to the case at bar.
That is a huge exception to the general rule we all learned.
It really is. The logic there is that Article 1544 tries to solve a conflict between two voluntary sales where a seller is actively double dealing.
Selling to A, then turning around and intentionally selling to B.
Right. But here in Kurumba, the conflict is between a prior buyer and an execution purchaser who is just trying to scrape value from a debtor through the court system.
The law protects the prior buyer of unregistered land because the registration system for unregistered land expressly says it is without prejudice to a third party with a better right.
And Kurumba simply had the better right because he owned the dirt.
This feels like the law prioritizing justice with a capital J over strict procedure with a capital P.
In this specific instance, yes, it does. It recognizes that the registration system for unregistered land is imperfect by nature, so it allows the actual truth on the ground to override the paper record.
Now, you mentioned earlier that this outcome would be totally different if the land had a Torrens title. I really want to make sure you listening grasp that contrast, because it's absolutely vital to protect yourself.
Completely different outcome. The source material contrasts the Kurumba case with another Supreme Court case, Rural Finance Court versus Palileo.
What happened in that one?
Justice Gankeko explained this one. It was a remarkably similar setup factually. You had a prior sale that wasn't registered by the buyer.
Okay.
And then a later execution sale by a sheriff that was registered.
But the land was different.
Yes. The land was registered Torrens land. It had a clean title.
And in that scenario, the execution purchaser wins.
The execution purchaser wins completely.
Why the flip-flop? Why does the Torrens system actively punish the first buyer who actually paid for the land?
Because of that operative act rule we talked about earlier. Oh, right. The registration creates the reality.
Exactly. With Torrens land, if the first sale isn't registered, as far as the whole rest of the world is concerned, it simply didn't happen.
The land still legally belongs to the debtor in the eyes of the state.
So when the sheriff levies on it, he is actually seizing something that legally still belongs to the debtor. He's not selling air this time, he's selling a valid title.
I see. So with Torrens land, the register is reality. It dictates the truth.
Yes.
But with unregistered land, the register is just a logbook of claims, but reality is what's actually happening on the ground with possession and private contracts.
That is a brilliant way to summarize it.
Yeah.
With Torrens, the register is the truth. With unregistered land, the register is just a notice, but it yields to the actual truth of ownership.
And Justice Gankeko noted that a bona fide purchaser of registered land at an execution sale acquires good title against a prior transferee if that prior transfer was unrecorded.
Correct. The Torrens system must be protected so people can trust the certificates. So the deeply practical lesson here for you listening. If you are buying land at a public auction, maybe you're looking for a bargain, thinking you're going to flip a distressed property, you need to check if it's Torrens or not.
Absolutely. You must verify that. If it's unregistered land, you are taking a massive risk at an auction.
Because you are buying whatever the debtor has left.
Which, as we saw in Karumba, might be absolute zero. Caveat emptor buyer beware applies with full force here.
You might think you're getting a great deal, but you might just be buying a lawsuit instead of a farm.
You might be buying a very long, very expensive fight with a guy like Karumba who is already living there and has the law on his side.
And as we just saw, Karumba is going to win that fight in court.
He is, every time.
Okay, so we've talked extensively about the sheriff scenario, but what about a regular, voluntary double sale? Does the better right doctrine always protect the first buyer of unregistered land?
Not necessarily. It's not just a magic wand you can wave. We have to look at another case to see the limits of this. National Grains Authority versus Intermediate Appellate Court. This case really helps us define what a better right actually looks like when you pit an unregistered deed against a Torrens title directly.
Who are the players in this one?
We have the Viva's spouses. They are the original sellers, and they sold some land to the Magcommit spouses.
Okay, Viva sells to Magcommit. Pretty simple so far.
But this wasn't a standard sale. This was a conditional sale, specifically a pacto de retro sale.
Pacto de retro. For those who skipped Latin class in law school, what does that translate to practically?
It's a sale with a right to repurchase. Basically, the seller says, I sell this to you now, but I retain the right to buy it back from you within a set number of years.
Oh, so it's often used almost like a loan with the land as collateral. If I don't buy it back, you just keep the land.
Exactly. It functions very much like a mortgage in practice. Now, importantly, the Magcommits had an unregistered deed for this transaction.
So, unregistered paperwork again. They are operating in the Act 3344 system.
Yes. Then we have the National Grains Authority, or NGA. They stepped in later as a third party.
And what did the NGA do?
The NGA actually became the registered owner of the land under the Torrens system. They got a clean certificate of title.
Oh, wow. So NGA has the actual Torrens title. Magcommit just has the unregistered deed of conditional sale. This is a clash of titans. Or maybe more like a titan versus mortal.
It is a total mismatch. And the legal question was, can the registration of that conditional sale to Magcommit under Act 3344 somehow defeat the NGA's Torrens title?
Based on everything we just learned about the two worlds, I'm guessing the Torrens title is the ultimate trump card here.
It absolutely is. Justice Paris explained that while the registration of the conditional sale might be binding on third persons generally in the unregistered world, it is by express provision of law without prejudice to a third party who has a better right.
And NGA clearly has the better right.
Obviously. NGA is the registered owner under the state-guaranteed Torrens system. That right is fundamentally superior to someone holding a mere unregistered deed of sale or a deed registered under the inferior Act 3344 system.
So the hierarchy seems to be pretty clear. Torrens title is king. If you have a Torrens title, you beat the unregistered deed every time.
Yes.
But if nobody has a Torrens title, if it's an unregistered land claim versus another unregistered land claim, then actual prior ownership and possession beats a later registered execution sale.
That is a really solid, practical summary. The better right usually favors the Torrens title holder, but down in the swamp of unregistered lands, the better right favors the person who actually acquired ownership first, regardless of who won the paperwork race.
It's basically about substance over form in the unregistered world and strict form over substance in the Torrens world.
That is a fascinating duality. It's like we really do have two entirely different concepts of justice operating side by side in the property laws.
We do. One system values absolute certainty above all else, that's Torrens, and the other values fundamental equity.
Exactly.
Okay, this brings us to a really weird technicality that I found fascinating when reading through the notes. It's almost comical if it weren't so tragically expensive for the people involved.
I know what you're talking about.
The wrong box theory.
The wrong box. This is all about improper registration. This is about what happens when you file your perfectly valid paperwork in the wrong system.
It sounds like a bureaucratic comedy of errors. Can you actually register a document in the wrong book? Like the clerk at the desk just takes it and puts it in the wrong pile.
You can, and people definitely do, and the legal consequences are totally fatal to your claim.
Let's talk about the case of Mactan Cebu International Airport Authority versus Terrell. What exactly happened there?
In this case, there was a deed of absolute sale for a piece of property. But the land in question was already Torrens registered land. It had a clean title. It was fully in the modern system.
Okay, so if you are registering a sale for that land, you should obviously be going to the Land Registration Act books under PD 11029.
Right. You should be looking for the transfer certificate of title and having your sale annotated right on it.
But that's not what happened.
No. For some reason, the buyer registered the sale under Act 32344.
The book for unregistered land.
Yes.
Why would anyone do that? Was it just sheer negligence?
Maybe confusion, maybe a mistake by the receiving clerk, or maybe they just didn't do their due diligence to check if the land was already titled.
Maybe they wanted to save on fees or avoid the strict requirements of the Torrens registry.
It's possible. But whatever the reason, they put the paperwork in the unregistered land system. They basically put the Apple software on the Android phone.
And what did the Supreme Court say when this inevitably went to trial? Did they say, well, you tried, close enough?
Definitely not. Justice Renato Puno was very, very clear. He said this is improper registration.
And what is the penalty for improper registration?
He stated that improper registration is no registration at all.
Ouch. No registration at all. That's incredibly harsh. It's not just categorized as bad registration, it's legally non-existent.
It means it's totally invisible to the law. It does not provide constructive notice to the world.
Because if you look for a Torrens title, you look in the Torrens book.
Exactly. You aren't expected to check the unregistered book just in case someone made a filing mistake. That would defeat the whole purpose of the Torrens system.
That makes total sense. If I'm buying a house, I check the main title. I'm not going to spend hours checking the miscellaneous pile or the lost and found bin just to be safe.
Right. So if you buy that land from the original owner and you check the Torrens registry, it looks perfectly clean.
So I buy it in good faith.
And then the guy who registered in the wrong box pops up out of nowhere and says, hey, I registered this sale years ago.
You win. He loses.
Because his registration was in the wrong place, it simply didn't count as notifying you. Justice Puno said a sale that is not correctly registered is binding only between the seller and the buyer, but it absolutely does not affect innocent third persons.
That is a truly harsh lesson in bureaucracy. You have to file in the right line. You can't just throw paperwork at a government building and hope it sticks.
It gets even more specific and honestly a bit weirder in the case of Salida versus Kalasia.
Let's hear it.
This one is interesting because it deals with splitting the property into the land and the house on top of it.
Oh, the old I own the house but not the land situation.
That always causes problems.
Sort of, yes. Here, a creditor wanted to attach or put a lien on a house to secure a debt.
Yep.
The house was built on land that was fully registered under the Torrens system.
So the land has a titanium title.
Yes. But the creditor claimed, well, the house itself isn't registered separately, so I will register my attachment just on the house under Act 3344, the unregistered system.
Trying to be clever.
Yep.
Treating the house as a separate unregistered entity just to bypass the Torrens requirements for the land.
Exactly. He probably thought, the land is Torrens, but the bricks and mortar are just physical stuff. I'll register a lien on the stuff.
And how did the Supreme Court view this creative filing? The court, through Justice Barrera, completely shut that down. They invoked a very old principle of property law. Accessory follows the principle.
Accessory follows the principle. I remember that from basic property law in my first year. What does that mean in this specific context?
It means the land is always considered the principal thing. The house is permanently attached to the land, making it merely an accessory to the land.
So unless the title explicitly says otherwise, the land title automatically includes the improvements built on it.
The house is legally part of the land. You simply cannot separate them conceptually just for the sake of easier registration.
So you can't split them up to use two different registries.
Not like that. Justice Barrera explained that the text of the law uses the specific words, its own improvements only, when referring to the unregistered land books.
Meaning Act 3344 is exclusively for unregistered land and the improvements built on that unregistered land.
Precisely. You cannot use Act 3344 to register a lien on a house that happens to sit on Torrens registered land.
So what ultimately happened to the creditor's lien on the house?
It was declared totally invalid.
Because it was in the wrong box.
Because it was in the wrong box. A man named Salida ended up buying the land, which obviously included the house. He had a clean Torrens title to the whole thing.
And the creditor tried to enforce the lien against Salida.
He tried. The court said absolutely not. Salida took the property entirely free of the lien because the registration under Act 3344 was legally void from the start.
It's amazing how specific the wording of these statutes is. Own and only. Those two words decide who gets a house.
Yes. Unregistered land and its own improvements only. To hold otherwise, the court said, would create a totally anomalous situation where you have two conflicting registrations for the exact same physical property.
One for the land under Torrens and one for the house under Act 3344. That would be an administrative nightmare.
It would be pure chaos. You'd have conflicting records everywhere, and nobody would ever know what they were actually buying.
So if I'm a creditor and I want to attach a house, say someone owes me a lot of money and I want to secure it against their mansion to make sure I get paid, I have to check the status of the land first.
100%. Justice Barrera specifically pointed out that the creditor in this case knew the house was built on land bought from a company called C.M. Hoskins and Company.
So the creditor should have investigated further.
If the land is titled, you must file a formal petition to annotate your land directly on the land title. You use Section 112 of Act 496, which is now Section 108 of PD 1529. You do not ever go to the unregistered book.
It really emphasizes that you cannot be lazy with your due diligence in property law.
Diligence is the currency of the law. If you are lazy or if you try to take administrative shortcuts by using the wrong registry, you lose all your legal protection.
Okay, we've been talking a lot about what not to do. Don't use the wrong box. Don't ignore the Torrens title. Let's switch gears to the actual mechanics.
Good idea.
How do you register unregistered land properly? If I buy a plot that has never been titled, maybe it's ancestral land in the province, or just land that slipped through the cracks over the decades, what is the actual physical process?
It is governed by Section 113 of PD 1529. The Register of Deeds keeps a day book and a register.
A day book? That sounds like a diary. Dear diary, today someone bought a farm.
It essentially is a chronological diary. It tracks every single document that comes in by the minute and the hour.
Why is the time so important?
This is crucial for establishing priority in time in case two people try to register at the same time. The process is known legally as mere presentment.
Mere presentment. That phrase implies the Register of Deeds isn't really doing a deep investigation into the validity of the sale.
They aren't. They aren't judges. They don't hold hearings. They are strictly recorders. You present the instrument, like the deed of sale.
And then what?
If it's found to be procedurally in order on its face, it gets registered. If it's defective in some formal way, the Register of Deeds refuses it in writing and has to give a specific reason why.
What exactly makes a deed in order? What does it legally need to say? If I just scribble, I sold this land to John on a napkin, will they take it?
Definitely not. It needs to be very formal and very specific. It must clearly state the character of the contract, all the conditions, and the exact description of the land.
Description like the big green field by the river.
No, much more precise than that. It needs metes and bounds. Boundaries, the exact area in square meters, and references to monuments.
Monuments, statues of national heroes.
No, in surveying terms, monuments are permanent markers physically placed on the ground like concrete blocks, large distinct trees, or steel rods that define the exact corners of the property.
So the deed needs to reference these specific points so anyone looking at the map knows exactly where the land is.
Yes. And as we discussed with the Salida case, it must list the permanent improvements on the land. And remember that key phrase, unregistered land and its own improvements only.
Right. Don't try to mix Torrens improvements into the unregistered deed.
Exactly. If you bring a deed that tries to mix Torrens land into the unregistered book, the Register of Deeds actually has a duty to reject it outright. They have to keep the books clean and separate.
Now, there is one edge case the notes mentioned that I think is really important for anyone currently in the middle of a legal battle or a conversion process.
The pending registration scenario.
Yes. What if the land is currently in court? Like, I'm in the middle of converting my unregistered land to a shiny new Torrens title. I filed the petition, the court is hearing all the evidence, but the final decree hasn't been issued yet by the judge.
Okay.
And then, while this is all pending, I decide to just sell the land to someone else.
This is a really critical timing issue. This is pending registration. You are basically in the transition zone between the two operating systems.
You have 1 foot in the unregistered world and 1 foot in the modern court system.
Yes.
So what does the buyer do? Do I use Section 113 in the daybook? Do I run down to the Register of Deeds and file my paper?
No, you absolutely do not. If you do that, you might fall into the better right trap again. If the land registration proceeding is already actively happening in court, you have to follow Section 22 of PD 1529 instead.
And what does Section 22 require me to do?
It says that since the court already has formal jurisdiction over the land, you have to bypass the registry and go straight to the court.
So the interested party, the new buyer, presents the instrument of sale directly to the judge.
Correct. You present the deed, plus an approved subdivision plan if you're only selling a piece of it, directly to the court. You file a formal motion.
And what does the court do with it?
The court will review it and then order that the final decree of registration be issued subject to this new deal. Or they might just order the decree to be issued directly in the name of the new buyer right from the start.
That seems so much safer. You are basically intercepting the title before it even gets printed at the registry.
Exactly. It's the smartest move. If you ignore the court case and just try to register in the unregistered book under Section 113, you run the massive risk of the new title being issued to the original seller because the court simply didn't know you bought it.
Then the seller has the titanium Torrens title, and you just have a deed in the weak 3344 book.
And then you have a very messy, expensive lawsuit to try and get the title back from him. The National Grains Authority case we mentioned earlier really touched on this risk.
You want to make absolutely sure your interest is captured in the title the moment it is born.
You want to be on the birth certificate of the land, essentially.
This has been a complete whirlwind tour of legal pitfalls. I feel like we've walked through a minefield today.
We definitely have. Property law is complex.
Let's try to summarize the big takeaways for the listener who might be feeling a bit paranoid about their own property rights right now.
I think the single biggest takeaway is understanding the concept of the two worlds. You cannot treat all land in the Philippines the same. You have to know which game you are playing.
World 1 is the Torrens system.
It is rigid, formal, and the public record is absolute king. If your claim is not on the title, it doesn't exist to third parties. Speed of registration is your ultimate weapon here.
And World 2 is unregistered land.
It is much murkier. It is a purgatory. Here, the registry under Act 3344 is really just a holding area for claims.
It doesn't guarantee ownership the way Torrens does.
No, actual rights. Who really owns it, who really possesses it on the ground, can often trump the paper trail in the registry.
And the better right doctrine is essentially the bridge between them, or the referee.
It is the referee. It says that a Torrens title is automatically a better right than an unregistered deed.
But between two unregistered claims.
Between two unregistered claims, the better right is the one that represents true prior ownership, like we saw in the Karumba case, even if the other guy managed to get a sheriff to sign a paper and register it.
And let's definitely not forget the wrong box.
Never forget the wrong box. Improper registration is no registration. Check the title first. If there is a title, touch the Torrens book.
If there is no title, use the Act 3344 book. Do not cross the streams.
It really highlights that registration isn't just about doing paperwork for the sake of bureaucracy. It is the legal method of notifying the whole world.
That is really the philosophical core of it all, isn't it? Registration is constructive notice.
You are shouting to the world, "This is mine." But if you shout in an empty room by using the wrong registry, nobody hears you, and the law won't protect you when someone else claims it.
It's fascinating because we usually think of the law as protecting the person who strictly followed the rules and filled out the forms in triplicate.
But in the Karumba case, the law protected the guy who didn't fill out the public forms over the guy who relied on the public execution sale. It is a really striking paradox in the law. The system usually rewards diligence. But in Karumba, the court decided that true justice meant protecting the actual owner over the procedural winner.
Because the sheriff cannot sell air. He cannot sell what doesn't exist anymore.
Exactly. It's a profound protection of true property rights over blind bureaucratic procedure.
Which leads to a really provocative final thought for you listening. If the law protects the unregistered first buyer against an execution purchaser, does that create a hidden danger for anyone buying land at an auction?
It absolutely does. It completely turns the concept of a safe judicial sale on its head.
I mean, think about it. You go to a sheriff's auction, you see a nice plot of unregistered land, you check the Act 3344 book, it's completely empty, the seller seems to own it free and clear.
So you buy it, you register it, you think you're completely safe.
And then, a month later, someone walks out of the woods holding a crumpled private deed from 2 years ago and says, "Sorry, I bought this already."
And the Supreme Court says he wins.
That is exactly the risk. It turns a judicial sale of unregistered land into a complete gamble. You are essentially betting your money that there is no Karumba hiding in the bushes with a private deed.
Is buyer beware the only rule that truly matters when the Torrens title is missing? It really seems like without that title, you are always looking over your shoulder.
Without a Torrens title, you are buying history. And history is very often unrecorded. You are buying the ghosts of previous transactions.
That is exactly why the national conversion to the Torrens system is so vital. It permanently ends the history lesson and starts a fresh, clean page. Until then, Buyer beware indeed.
A very sobering thought to end on today. If you're buying land, get a good lawyer, check the right books, and maybe, just maybe, knock on the door and ask who lives there first.
That is very sound advice. Sometimes the best due diligence is just a simple conversation with the neighbors.
That's it for this deep dive into land registration. Hopefully you now know exactly which box to check and which book to read. We'll catch you on the next one.
Welcome to the debate. Imagine this scenario. You save up for, well, a decade to buy a plot of land. You check the public records, and it's clean. So you pay the seller, you register the sale, and you get the title in your name. You sleep soundly. Then, maybe 3 years later, someone knocks on your door holding a crumpled, yellowing contract from 5 years ago. They claim they bought the land before you did. They never recorded it. They never told the government, but they say they have a better right. Who owns the land?
It is the ultimate nightmare. And depending on which system of law applies to that specific patch of dirt, the answer might actually be the person with the crumpled paper.
Right. Today we are dissecting the high-stakes conflict between the certainty of the public record and the reality of actual ownership. We are specifically looking at the transition from the old Spanish mortgage law to the modern Philippine system under Presidential Decree 1529.
We are essentially debating a question that has plagued property law for, a century. Does the piece of paper create the ownership, or does ownership exist independently of the paper?
I will be arguing for the primacy of the registration system, specifically the Torrens ideal. In a modern economy, the public record really has to be the final word. If we can't trust the title, we essentially have no market.
And I'll be arguing for the better right doctrine. My stance is that a registry is a tool, not a magic wand. Especially regarding unregistered lands, you cannot use the bureaucracy to steal what someone else legally bought and paid for, just because they were, slow to file the paperwork.
Our discussion today draws from legal reviews of Presidential Decree 1529, focusing heavily on Section 113 regarding unregistered lands, and how that clashes often violently with the rules for titled property.
This isn't just academic. This is literally about whether you actually own the roof over your head.
Let's lay out our positions. My argument is built on stability. We operate primarily under the Torrens system. For those listeners who aren't property lawyers, the Torrens system is a state-guaranteed system of land titling. The government issues a certificate, and that certificate is the evidence of ownership.
It's the mirror principle. The title should mirror reality.
Exactly. My position is that the act of registration is the operative act to convey land. I am looking at the reasoning of Justice Genkaiko in the case of Rural Finance Corporation versus Polileo. The logic there is stark. If property is registered under the Torrens system, a bona fide purchaser, someone buying in good faith, acquires good title even against a prior unrecorded transfer.
Bona fide purchaser being the key phrase there, meaning you didn't know about the other guy.
Correct. And my point is, I shouldn't have to know. The law protects the innocent third party who relied on the state certification. If we allow secret deals and unrecorded contracts to defeat a registered title, we introduce a level of risk that makes buying property a gamble. I'm standing on Article 1544 of the Civil Code. If land is sold to two people, the ownership belongs to the one who registers it in good faith. It's a race of diligence.
That is a very clean, very first world way of looking at it. But I am looking at the messy reality of the landscape. My position is that for the vast swaths of land that are not yet fully covered by a Torrens title, what we call unregistered land, the rules are fundamentally different.
Different or just older?
Different by design. I'm looking at Section 113 of PD 1529. Yes, it allows you to record deeds for unregistered land, but the law explicitly adds a caveat. It says this registration is without prejudice to a third party with a better right. That phrase does a lot of heavy lifting. It means the registration yields to the truth.
So you're saying the registry is just a suggestion?
I'm saying it's a notification, not a validation. I rely on the logic of Justice J.B.L. Reyes and Carumba versus Court of Appeals. The principle is simple. You cannot sell what you do not own. If a person sells their land to me via a private handshake and a contract, they no longer own it. If a sheriff comes along later and tries to sell that land to pay off the original owner's debt, the sheriff is selling nothing. and you cannot register nothing and turn it into something.
That is the crux of it, isn't it? Whether the registry creates the right or merely records it. Let's dive into the core debate. I want to challenge this better rights concept because I think it breeds absolute chaos.
Chaos or justice?
Chaos! Look at Section 51 of PD 1529. It states clearly that for registered land, an unrecorded deed takes effect only as a contract between the parties. It does not bind the world. It does not bind the third party. If I buy a house and you show up 5 years later with a private contract, Section 51 says your contract is your problem, not mine. Why should unregistered land be treated differently?
Because the law acknowledges that the transition to the Torrens system isn't finished. You are applying the strict rules of a perfected system to a system that is still evolving. Look at the National Grains Authority case. Justice Paris had to deal with this exact tension.
But in that case, the National Grains Authority actually held the Torrens-titled, didn't they?
They did. But the reasoning is what matters. The court acknowledged that for unregistered land, the registration is without prejudice to better rights. It implies that the registry isn't a fortress, it's a notice board. If the facts and circumstances, and that is the specific language used, show that someone else has a superior claim based on possession and prior sale, that reality wins.
But pause on facts and circumstances for a second. That sounds incredibly vague. As a buyer, how am I supposed to audit the facts and circumstances of a property's history? I check the registry of deeds. That is my due diligence. If you tell me I also need to interview the neighbors, check for hidden contracts, and act like a private investigator, you are paralyzing the market.
For unregistered lands, yes, you absolutely have to play detective. That is the warning the law gives you. When you deal with land that isn't Torrens-titled, you are on notice that the system is not conclusive. You're buying the rights as they exist, not just what is on the paper.
I find that deeply unsettling for the average home buyer. But let's pressure test this with the double sale dilemma. This is Article 1544 of the Civil Code. It provides a flowchart for fairness. If a person sells land to two buyers, who wins? Step 1, the one who registers in good faith. Step 2, if no registration, the one who possesses in good faith. Step 3, if neither, the one with the oldest title. It's logical, it's predictable. Why do you insist this doesn't apply to execution sales?
Because an execution sale where a court orders a sheriff to sell property to pay a debt is not a sale in the voluntary sense. This is a distinction that Justice J.B.L. Reyes hammered home in Carumba.
But a sale is a sale. Money changes hands, property changes hands.
No, the source of the right is completely different. In a double sale under Article 1544, you usually have a crooked seller trying to sell the same land to buyer A and buyer B. They are both victims. The law has to pick a winner, so it picks the diligent one who registered. But in an execution sale, the sheriff is stepping into the shoes of the debtor. The sheriff can only sell what the debtor actually has at that very moment.
Ah, the step into the shoes doctrine.
Exactly. In Carumba, the debtor, let's call him Mr. X, sold his land to Canuto via a private, unrecorded document. Canuto took possession. 2 years later, a creditor sues Mr. X and the sheriff levies the land. Here is the catch. At the moment the sheriff levied the land, what did Mr. X own? Nothing. He had already sold it. He had no dominical interest, no ownership interest left.
Even though the public record still showed Mr. X as the owner?
Yes, because for unregistered land, the recording isn't what transfers ownership. The delivery and contract do. So when the sheriff sold the land to the creditor at the auction, he sold heir. The creditor registered that sale, but registering heir doesn't turn it into land.
That is a harsh interpretation for the creditor. I mean, they followed the rules, they checked the record, they won the lawsuit, and they end up with nothing because of a secret handshake deal 2 years prior.
It's not a secret handshake. It was a valid contract and actual possession. The creditor's mistake was assuming that the paper record was the only reality. In execution sales, the doctrine of caveat emptor, buyer beware, applies with extreme prejudice. You only get what the debtor actually has, hidden worths and all.
I see the legal mechanics, but I still argue that this loophole discourages lending.
If banks can't rely on the levy process because a secret owner might pop up, they simply won't lend. However, I want to pivot to a situation where even you might agree that the better rights argument falls apart. We need to talk about the anomalous situation.
Ah, you're referring to Salida versus Kaleja. This is where things get really messy between the two systems.
It is a fascinating case. You had a creditor who wanted to register an attachment, a lien on a house. But the land the house sat on was already registered under the Torrens system. The creditor, for some reason, registered the lien under Act 3344, which is the system for unregistered land.
Right. They filed the paperwork in the completely wrong book.
Justice Barrera was unforgiving here. He called it improper registration. And improper registration is no registration at all. The law uses the phrase own and only. Registration under Act 3344 applies to unregistered land and its own improvements only. You cannot use the unregistered system to tag a house that sits on registered land.
I have to concede that is a technical knockout.
The principle is that the accessory follows the principle. If the land is Torrens, the house is Torrens. You can't split the legal personality of the property just to suit your filing convenience. But it's more than just a technicality. It's about notice. If I am a prospective buyer, I am checking the Torrens title. I am not going to go into the dusty basement archives of Act 3344 to see if someone put a sticky note on the house. That would be absurd.
It would be. But looking at Salida, do you think the creditor just made a clerical error? Or was there something else?
Well, the source material suggests it was negligence.
It was worse than negligence. The notice of attachment itself admitted that the land was bought from C.M. Hoskins & Co. Now, C.M. Hoskins was a major developer. If you buy from a developer, 99% of the time, that land is titled.
So the creditor knew, or at least should have known, that there was a Torrens title involved.
Exactly. They knew it was likely titled land, but instead of doing the hard work of finding the title number and filing the lien properly, they took the lazy route. They filed in the unregistered book because it was easier. In that specific instance, I totally agree with you. The better right cannot protect you from your own laziness.
This reinforces my core thesis. Procedure isn't just red tape. Procedure is protection. If you file in the wrong place, you are shouting into the void. You provide no constructive notice to the world.
Constructive notice is a powerful concept. It means the world is assumed to know, even if they don't actually know. But if you file in the wrong registry, that magic spell just doesn't work.
Which leads us to the final and perhaps most confusing category of land. We've talked about registered, we've talked about unregistered. What about the land that is stuck in the middle, land that is pending registration?
The twilight zone. This is where an application for a title has been filed in court, but the decree hasn't been issued yet.
If you were buying land in this state, can you just record the sale under Section 113 for unregistered land?
Absolutely not, and this is a trap many people fall into. Once the land is under the jurisdiction of the court, the administrative system of the Register of Deeds takes a back seat.
You have to use Section 22 of PD 1529. You must go to the court.
Right. If the case is ongoing, you have to present the deed of sale to the judge. You have to ask the court to either register the land subject to your new interest, or if you bought the whole thing, to issue the decree directly in your name.
And if you skip that, if you just go to the Register of Deeds and file it in the daybook?
It's useless, because the court might issue the title to the original applicant completely unaware that you bought it. And once that title is issued to the original guy, good luck getting it back. You are now fighting a Torrens title.
This proves that the system works if, and only if, you identify the status of the land correctly. The procedural posture dictates the validity of your claim. You cannot treat all land as generic property.
I suppose that is where we diverge slightly on the philosophy, even if we agree on the mechanics. You see the procedure as the source of the right. Follow the steps, get the land. I see the procedure as the confirmation of the right. But I will admit, in the case of pending proceedings, bypassing the court is a recipe for disaster. You are essentially trying to bypass the judge who holds your fate in their hands.
It is a recipe for losing your investment entirely. So let's try to synthesize this for our listeners. We have a fractured landscape.
We do.
We have the Torrens Fortress, the unregistered Wild West, and the pending Twilight Zone.
If I am to summarize my position, while the better right doctrine exists for unregistered land, relying on it is a gamble. It is a defensive doctrine, not an offensive one. You use it when you are being sued, not to secure your asset. The safest path, the path that modern law encourages, is the Torrens system. Registration is the shield against the world. As Justice Genkaiko noted, a bona fide purchaser shouldn't have to look further than the title. If we want economic stability, we must prioritize the certainty of the record. And I come at it from the human perspective. The law, in its wisdom, recognizes that a piece of paper is not the land itself. For the vast areas that are still unregistered, Section 113 acts as a safety valve. It preserves the better right. If I bought it, paid for it, and lived on it, a sheriff selling my land to pay someone else's debt is unjust. The law protects me, even if I didn't file the paperwork. The reality of ownership weighs heavier than the formality of registration in these specific cases.
It is a tension that likely won't disappear until every square inch is brought under the Torrens system.
And even then, the human element, bad faith, double dealings, fraud, will test the system. The mirror will always have cracks.
I want to leave our listeners with a final reflection from Justice Puno in the Mactan Cebu International Airport case. It is a simple rule, but devastating if ignored. Registration must be done in the proper registry to be effective.
Yes. It's not enough to just register. You have to register in the right book. A sale registered under the wrong system, like using Act 3344 for Torrens land, provides no constructive notice. As the court said, improper registration is no registration at all.
So the actionable insight here is diligence. Check your titles. Know what kind of land you are dealing with. Is it Torrens? Is it unregistered? Is it pending? Because in the eyes of the law, where you file is just as important as what you file.
And if you are holding unregistered land, relying on your better right is fine, but getting that paper sorted out is probably cheaper than a Supreme Court case.
A valid point. The tension between legal certainty and actual justice remains a central feature of property law.
Indeed, there is always more to explore in the fine print.
Thank you for joining the debate.
What happened to lands previously registered under the Spanish mortgage law, and how are transactions involving such land to be registered or recorded?
The system of registration under the Spanish mortgage law was discontinued by PD 892, and this was reinforced by Presidential Decree 1529, Section 3. And all lands recorded under the said system, which were at that time not yet covered by Torrens-titled, were considered as unregistered lands. As to instruments affecting such land formerly covered by the Spanish mortgage law, specifically after June 11, 1978, all such instruments originally registered under the Spanish mortgage law may be recorded under Section 113 of Presidential Decree number 1529 until the land itself shall have been brought under the operation of the Torrens system. The books of registration for unregistered lands provided under Section 194 of the Revised Administrative Code, as amended by Act number 3344, continued to remain in force, provided that all instruments dealing with unregistered lands were thenceforth to be registered under Section 113 of PD 1529.
What is the effect of registration under Section 113 PD, numbered 1529, instruments or transactions involving unregistered lands?
Regarding the effect of registration under Section 113 PD 1529, the same yields to better rights of third persons prior to such registration. It therefore has limited effect on third parties. The better right that cannot be prejudiced by the registration of a second sale of a parcel of land referred to in Act number 3344, now Section 113 of PD 1529, is much more than the mere prior deed of sale in favor of the first bendee. Rather, it involves facts and circumstances in addition to the deed of sale, which combined would make it clear that the first bendee has a better right than the second purchaser. In National Grains Authority versus Intermediate Appellate Court, you would recall Justice Paras explaining that the registration of the conditional sale with right of repurchase may be binding on third persons. It is by provision of law understood to be without prejudice to a third party who has a better right. In this case, it will be noted that the third party, National Grains Authority, is the registered owner under the Torrens system and has obviously a better right than the magkamit spouses and Amelita magkamit. The deed of absolute sale with a suspensive condition, on the other hand, was not registered and is necessarily binding only between the Biba spouses, the sellers under the Pacto de Retro Sale, and the magkamit spouses and Amelita magkamit, the buyers therein.
Discuss the extent of the rights acquired by a purchaser at an auction sale involving unregistered lands.
The purchaser of unregistered land at a sheriff's execution sale only steps into the shoes of the judgment debtor and merely acquires the latter's interest in the property sold as of the time the property was levied upon. As explained by Justice J.B.L. Reyes in Carumba versus Court of Appeals, while under the invoked Article 1544, registration in good faith prevails over possession in the event of a double sale by the vendor of the same piece of land to different bendees. Said article is of no application to the case at bar, even if Balbuena, the latter bendee, was ignorant of the prior sale made by his judgment debtor in favor of petitioner Carumba. The reason is that the purchaser of unregistered land at the sheriff's execution sale only steps into the shoes of the judgment debtor and merely acquires the latter's interest in the property sold as of the time the property was levied upon. While the time of the levy does not clearly appear in this case, it could not have been made prior to April 15, 1957, when the decision against the former owners of the land was rendered in favor of Balbuena. But the deed of sale in favor of Canuto had been executed 2 years before, on 12th of April 1955, and while only embodied in a private document, the same coupled with the fact that the buyer, petitioner Carumba, had taken possession of the unregistered land sold, sufficed to vest ownership on the said buyer. When the levy was made by the sheriff, therefore, the judgment debtor no longer had dominical interest nor any right over the land that could pass to the purchaser at the execution sale. Hence, the latter must yield the land to petitioner Carumba.
Distinguish the rights acquired by a purchaser of registered land at an execution sale from those acquired by a purchaser at an execution sale involving unregistered lands.
The rule is different in case of lands covered by Torrens titles where the prior sale is neither recorded nor known to the execution purchaser prior to the levy, but the land here in question is admittedly not registered under Act number 496. So the deed executed 2 years before the execution sale, while only embodied in a private document, the same coupled with the fact that the buyer had taken possession of the unregistered land sold, sufficed to vest ownership on the said buyer. When the levy was made by the sheriff, therefore, the judgment debtor no longer had dominical interest nor any real right over the land that could pass to the purchaser at the execution sale. The rule is different in case of lands covered by Torrens titles where the prior sale is neither recorded nor known to the execution purchaser prior to the levy. In the case of Regiwealth Finance Corporation versus Palileo, Justice Gancaico explained that there is no doubt that had the property in question in that case been a registered land, that case would have been decided in favor of the petitioner therein, since it was the petitioner that had its claim first recorded in the registry of deeds. For as already mentioned earlier, it is the act of registration that operates to convey and affect registered land. Therefore, a bona fide purchaser of a registered land at an execution sale can acquire a good title against a prior transferee if such prior transfer was unrecorded. In this case, Justice Gangkaiko reasoned out as follows. If the same piece of land was sold to two different purchasers, to whom shall the ownership belong? Article 1544 of the Civil Code provides that in case of double sale of an immovable property, ownership shall be transferred 1. To the person acquiring it who in good faith first recorded it in the registry of property. 2. In default thereof, to the person who in good faith was first in possession. And 3. In default thereof, to the person who presents the oldest title, provided there is good faith. There is no ambiguity regarding the application of the law with respect to lands registered under the Torrens system. Section 51 of PD number 1529, amending Section 50 of Act number 496, clearly provides that the act of registration is the operative act to convey or affect registered lands insofar as third persons are concerned. Thus, a person dealing with registered land is not required to go behind the register to determine the condition of the property. He is only charged with notice of the burdens on the property which are noted on the face of the register or certificate of title. Following this principle, this court has time and again held that a purchaser in good faith of registered land covered by a Torrens title acquires a good title against all the transferees thereof whose right is not recorded in the registry of deeds at the time of the sale. The question that has to be resolved in the instant petition, therefore, is whether or not the rule provided in Article 1544 of the Civil Code, as discussed above, is applicable to a parcel of unregistered land purchased at a judicial sale. To be more specific, the Supreme Court is asked to determine who, as between two buyers of unregistered land, is the rightful owner. The first buyer in a prior sale that was unrecorded, or the second buyer who purchased the land in an execution sale whose transfer was registered in the Register of Deeds. Registration of instruments affecting unregistered lands is without prejudice to a third party with a better right. The aforequoted phrase has been held by the Supreme Court to mean that the mere registration of a sale in one's favor does not give him any right over the land if the vendor was not anymore the owner of the land, having previously sold the same to somebody else, even if the earlier sale was unrecorded. Applying this principle, the execution sale of an unregistered land in favor of the buyer therein is of no effect, where the land no longer belonged to the judgment debtor as of the time of the said execution sale.
With the recording of transactions relating to registered land in the registry for dealings involving unregistered land suffice to produce the effect of notice and registration?
In Mactan, Cebu International Airport Authority versus Tirol, the respondents therein were not characterized by the Supreme Court as buyers in bad faith for having brought property notwithstanding the registration of the first deed of absolute sale over the same under Act 3344. It was pointed out that this was improper registration, and improper registration is no registration at all. Likewise, a sale that is not correctly registered is binding only between the seller and the buyer, but it does not affect innocent third persons. Justice Reynato Puno explained in this case that it is well settled rule that registration of instruments must be done in the proper registry in order to effect and bind the land. Prior to the Property Registration Decree of 1978, Act Number 496 governed the recording of transactions involving registered land. Land with the Torrens title. On the other hand, Act Number 3344 as amended provided for the system of recording of transactions over unregistered real estate without prejudice to a third party with a better right. Accordingly, if a parcel of land covered by a Torrens title is sold but the sale is registered under Act Number 3344 and not under the Land Registration Act, the sale is not considered registered and the registration of the deed does not operate as constructive notice to the whole world. Consequently, the fact that one is able to register his deed of absolute sale under Section 113 PD 1529 is of no moment where the property subject of the sale is indisputably registered land. It is the act of registration that shall operate to convey and affect the land. Absent any such registration, the instrument executed by the parties remains only as a contract between them and as evidence of authority to the clerk or register of deeds to make registration.
May transaction involving improvements or interests in lands registered under the Torrens system be registered under the Registry for Unregistered Land?
Justice Barrera, in the earlier case of Salita versus Calleja, explained that in order to be registrable under Act 3344, the instrument must refer only to unregistered land and its own improvements, and not on any other kind of real estate or properties. The words own and only used in the language of the law when referring to improvements clearly mean improvements on unregistered lands alone. In fine, the deed cannot refer to improvements or buildings on lands registered under the Torrens system or under the Spanish mortgage law. To hold otherwise would result in the anomalous situation of two registrations, one under Act Number 496 with respect to unimproved land and another under Act 3344 for improvements subsequently introduced on the same land. In Salita versus Calleja, an attachment was made on a house erected on registered land. It is therefore evident that the registration thereof under Act 3344 was invalid and of no legal or binding effect on third persons, or more particularly on the plaintiff Salita. So, having failed to perfect his lien on the house in question in the manner indicated, he cannot enforce it against plaintiff Salita, the purchaser in good faith of the house and lot on which it stands. The fact that the clean title acquired by Salita did not mention the improvement does not preclude the acquisition thereof with the land described in the title. This is so because unless it otherwise appears on the title itself, the same includes not only the land described therein, but also all improvements existing on said land. After all, the accessory follows the principal. Furthermore, in this case of Salita versus Calleja, it is not disputed that in the notice of attachment of real estate, dated January 7, 1954, it was therein stated that the house in question was, quote, erected upon land bought from C.M. Hoskins and Company Incorporated on installment plan, and that said house has not been registered under either Act 496 or under the Spanish mortgage law. Knowing then that the land on which the house was built was bought from C.M. Hoskins and Company, Defendant Calleja should have investigated whether the land was duly titled, and finding that the same was titled, as in fact it was, in the name of Realty Investments Incorporated. He should have taken steps to perfect his lien on said house by filing a petition for annotation of the said improvement as well as the registration of his lien thereon on the title to the land, pursuant to Section 112 of Act Number 496, which is now Section 108 of PD 1529.
Describe, generally, the process of registration of dealings involving unregistered lands.
Section 113 PD 1529 requires the Register of Deeds to keep a daybook and a register and an index system. The procedure for registration of transactions involving unregistered land is done by mere presentment of the instrument. If found in order, the same is registered. If found to be defective, then the registration is refused in writing with reasons to be given by the Register of Deeds for his refusal. As noted by Justice Barrera in Salita versus Calleja, the register book is required to contain, among other things, the character of the contract and its conditions, the nature of its piece of land that is unregistered, and its own improvements only, and not in any other kind of real estate or properties. Its situation, boundaries, area in square meters, whether or not the boundaries of the property are visible on the land by means of monuments or otherwise, and in the affirmative case, in what they consist. The permanent improvements existing in the property are also required to be mentioned. Again, as noted by Justice Barrera from those provisions, it seems clear that in order to be registrable under Act Number 3344, the instrument must refer to unregistered land and its improvements only, and not on any other kind of real estate or properties. The words own and only used in the language of the law when referring to improvements clearly mean improvements on unregistered lands alone. In fine, the deed cannot refer to improvements or buildings on lands registered under the Torrens system or under the Spanish mortgage law. To hold otherwise would result in the anomalous situation of two registrations, one under Act 496 with respect to unimproved land and another under Act 3344 for improvements subsequently introduced on the same land. Since in the case at bar, the attachment refers to a house erected on registered land, it is evident that the registration thereof under Act 3344 was invalid and of no legal or binding effect on third persons. If unregistered land is pending land registration proceedings, the procedure to be followed in order to make the transaction binding on third persons and to avoid possible conflict with any intervening innocent purchasers for value, as has happened in the case of National Grains Authority versus Intermediate Appellate Courts, is that provided in Section 22 of PD 1529 instead of Section 113. Section 22 provides that after the filing of the application and before the issuance of the decree of registration, the land therein described may still be the subject of dealings in whole or in part, in which case the interested party shall present to the court the pertinent instruments, together with a subdivision plan approved by the Director of the Lands Management Bureau in case of transfer of portions thereof, and the court, after notice to the parties, shall order such land registered subject to the conveyance or encumbrance created by the said instruments, or order that the decree of registration be issued in the name of the person to whom the property has been conveyed by said instruments.